It's an absolute truism of investing, which is different from maybe a birthday or Christmas, is that no one really likes surprises. And it feels like we've been handed a bunch of surprises over the last 6 months. I'm sitting here in the middle of August of 2025, and I feel like every other week there's a new surprise coming down the road, a new opportunity for us to freak out about what's going on and how it impacts our portfolios and our investment strategies going forward in the United States.
You are listening to the AFIRE podcast, real estate, technology, cross-border investing, and the opportunities of a changing world. Let's start a conversation now.
As we're working through this, though, there are particular surprises that probably stand out more than other. And in June, I think we had a really big one as we were considering what was called the Big Beautiful Bill. So I'm especially glad to be able to sit down today with Shiukay Hung, who is the partner and co-chair of the National REIT tax practice at DLA Piper, who wrote an excellent piece back in June, helping explain what on earth was going on and what was at stake when it came to the Big Beautiful Bill, and who is going to be speaking at our September 9th annual meeting in New York City to help us understand how the world has changed in the last few months and how we should be approaching this. So that's a long introduction and probably longer than it needed to be. Shiukay, thank you so much for joining us on the AFIRE podcast.
Thanks for having me.
So we should probably start then by kind of talking about what happened. What was the great concern that we had as cross-border investors around the world investing in the U.S. property markets when it came to the Big Beautiful Bill?
Well, the Big Beautiful Bill is a very interesting piece of legislation. Perhaps it's one of the few tax legislation in recent memory that came with a lot of tax drama.
Tax drama. I like that. That should be the headline right there. Tax drama. For the first time in a long time.
For the first time, clients wanted daily updates on what was happening in the world of tax, and I just don't get that very much. So what happened here and how can we unpack it a little bit? With the One Big Beautiful Bill, the objective and the primary purpose of the bill was to create a pro-growth environment. It was to maintain tax cuts that were proposed under the Tax Cuts and Jobs Act under the first Trump administration and to continue along that trajectory because a lot of those tax cuts were scheduled to expire. So One Big Beautiful Bill was meant to continue the United States on the same trajectory and along the same policy. So you might be hearing a message that everything is continuing along the same line. So why was there this uproar and all this concern about as to what was happening for foreign investors? Well, with any budget, there's a concept of balancing. And with all the tax cuts and continuing these tax cuts, the question became, how will the United States pay for these tax cuts? And one item that parties have circled around as a possible pay for was this so-called retaliatory tax. This retaliatory tax would have been a tax on foreign investors if they're from a country with an unfair tax practice. Now, the concept of unfair tax practice, unfortunately, stretches to a lot of countries. We're talking something in the region of 140 countries. So basically almost everyone.
So the idea would be this retaliatory tax. How big a tax was it? How big was the threat?
The other interesting point, as you can tell by the name is a retaliatory tax. So it did not shy away from how great of a tax this would be. Under one of the proposals, the tax could be as high as a 50% withholding tax. Now, imagine your investment. If you were suddenly levied a 50% investment from previously, perhaps you were used to being subject to a withholding tax of 0, that's a huge impact on your total return.
It doesn't pencil out well.
And this retaliatory tax also had an interesting feature and something perhaps that we've never seen before. The concept with the retaliatory tax was, on the one hand, it was meant to raise revenue, and it was one of the biggest proposed revenue raisers under One Big Beautiful Bill Act. But on the other hand, it was also meant to be leverage, meaning the administration really didn't want to truly levy the tax because they would much rather that those unfair countries drop their unfair tax practices. These are tax practices relating to international taxation that the United States felt were detrimental or unfairly burdening U.S. multinational companies.
Mm-hmm.
So as an investor, you might be hearing this and thinking, hey, this is almost like two sides of the brain. From an investor perspective, you're putting on your investor hat on. You're saying, why should I be part of the equation to pay for something that multinationals are doing? You might be feeling that you are like an unfair participant in this to be paying this tax. And that was exactly the reaction that foreign investors reacted to when this proposal was given.
Well, part of what I find interesting is that it didn't happen. It was something that we were all frightened of. I think it was called Section 899 to the tax code, or was proposed to be that. And there was a lot of concern about that in June before it was passed. And then it seemed almost at the 11th hour, it miraculously disappeared. And all of us in real estate dodged a significant bullet in terms of allowing institutional real estate from around the world, the investors, to continue investing without fear of that particular retaliatory tax. But when I was chatting with you after the fact, I heard something somewhat disturbing from you, which seemed to imply that we are in a different environment now in terms of tax risk or something occurring. Can you explain what that is and why we should be concerned now that somehow we dodged the bullet? We should be fine, but maybe it has changed.
There's actually a lot to unpack there. So if you think about One Big Beautiful Bill, and you look at what has happened, 899 came as a little bit of a surprise to some people, but actually it's a proposal that's been around since January, February of this year.
Right.
So there have been breadcrumbs for people to follow if you're truly following this issue. On the issue of change in law risk, for so long, foreign investors have been attracted to the U.S. market and the U.S. real estate market, not only because the remarkable returns that we generate here in the United States, but also for our stable legal system, our stable tax law, which helps give certainty to a foreign investor-friendly investment environment.
Right.
Now, when you hear a proposal such as 899 and the name retaliatory tax on foreign investors, you cannot help but wonder, has this environment changed? Now, perhaps you can get some comfort to the point you were saying this proposal was proposed. Different stakeholders gave their feedback on this proposal, and this proposal was ultimately dropped. So where is the tail risk on this retaliatory tax, and could it come back in the future? When the retaliatory tax was dropped late in the legislative process, it was under an understanding and an agreement that the G7 countries would drop or reform their unfair foreign tax practices that were of concern to the administration. To date, no formal agreement or proposal has been enacted into law yet. So there still remains a tail risk that this could all fall apart, and maybe there will be a need for 899 to come back again in order for the administration to have the leverage it needs to get rid of the unfair foreign tax practices that it would like to disappear in order to further advantage U.S. multinational companies.
Let me get this right. So we got rid of the 899 provision, and yet the fact that it's been brought up in the past, it could come back in the future, is a different environment. Because a year ago, we weren't thinking about retaliatory taxes being even on our horizon. But now it's a possibility, and therefore we now have a new risk to consider. Is that an accurate reflection?
That is an accurate reflection, and perhaps there's a little bit more there to unpack than that too. Before 899, the proposal of 899, there were certain technical issues that people were not so clear on how it will work in reality. For so long, people had thought that income tax treaties were supreme and that surely we would not have a domestic law that would override a treaty. With 899, it has shown us that the possibility of overriding a treaty is not impossible. Perhaps we would go into that world whereby domestic law, we would choose to override a treaty.
Right.
So then in terms of assessing risk for a foreign investor and deciding what structures might be the riskiest versus which structures might be the safest, one thing to ask now in a post-899 world is, are you relying on a U.S. income tax treaty? in the old world, one might say, hey, if I'm relying on a US income tax treaty, that might be the safest structure because it will be perhaps considered an international faux pas to have any sense of overriding an international agreement. But what 899 has taught us that perhaps a domestic tax exemption is safer than an international one offered under the US income tax treaty. So for example, 899 has shown us that the exemption for interest withholding under the portfolio interest exemption is perhaps one of the safest exemptions that you can rely on now because that is a domestic tax exemption rather than one under a treaty.
It is different from an environment where no one even thought about it. It was not really a main concern unless, we called you and said, what are you concerned about as a tax specialist? That most investors really didn't have it on the horizon. That it is on the horizon. It means that we need to look. I like this idea of thinking in terms of, trying to work within the domestic tax regime versus, relying on treaties. It makes a lot of sense in the current environment as the geopolitical situation has shifted. At the same time, there are certainly in the drama of the first half of this year was a lot of drama. The end result, not so bad. The end result, we kind of got past the worst of it. It seems to me, though, that we also need some sort of guidance as to what should I pay attention to as an investor. It's not the headlines that I should be paying attention to. If I value my blood pressure being low and my stomach lining being protected, I probably shouldn't pay too close attention to the sausage making, if you will, of politics. And it is difficult to understand what's going to happen if you are paying too close attention to the rhetoric. So if that's the case, what should I pay attention to? How should I be following? Certainly from a tax risk perspective, what should investors be paying attention to?
Right. So I think that's a really good question. From an investor perspective, it is important to keep track of the proposals and the announcement coming out from Washington. But at the same time, you need to take a lens of not overreacting. These proposals are out there, the legislative process is working, and the politicians are listening to feedback.
Mm-hmm.
And as they are listening to feedback, they are concerned on how it will impact the economy. So again, drawing from 899, what we have noticed is during the 899 process was that stakeholders were very concerned with 899 and what might be the impact on the bond market, and specifically the 10-year mortgage rate.
Right.
So while you might be thinking from a very surgical perspective of like, what is my individual exemption and my own treaty and how is that impacted? You need to take a broader scale macro view to think about, okay, if this provision were to be enacted, what would be the impact on the macro economy, and would that make good economic and business policy? And if not, there's probably a good chance that it will fall away.
It seems to me that we constantly have to be reminded of the lesson that many politicians and many leaders of the U.S. government have learned over the decades, which is the bond market is the ultimate boss in some ways. That to a certain extent, depending on where the 10-year treasuries go, that will determine whether or not a policy is a wise one or not, and whether or not there's enough support for it to go through. That seems to me that the 10-year treasury, the bond market, essentially pulled the chain a little bit and said, oh, hold on there. This is not a direction for you to go. Do you think we can rely on that in the future?
I think we can. I think that will be a guiding principle for years to come. And I think another interesting fact that got flushed out during the whole 899 process was an examination of U.S. borrowers and how they enter into borrowing arrangements.
Right.
Typically, when a U.S. borrower enters into a borrowing arrangement, most credit agreements will have a provision in there to protect the lender from a change in law risk. So in the example that we were talking about right now, imagine if you're a U.S. borrower and you enter into a credit agreement to borrow from a foreign lender years ago, and you're still drawing down money from the credit facility, or your credit facility continues to be outstanding. A change in law that happens after you signed the agreement, the tax gross up actually falls on the U.S. borrower rather than a foreign lender. So again, with that additional facts and with that additional data, that really changed people's view on who was truly bearing this extra tax.
Part of the discussion is that all the parties that are engaged in this have to understand who's paying at the end of the day. And I think there's a lot of misunderstanding about that, some of it intentional, some of it unintentional, in terms of who ends up paying for this. And it seems to me the more we understand who ends up having to pay the bill, the more rational some of the decision-making becomes. That certainly is the case that we had here. I mean, I don't know how much I can sleep at night just based on my faith in the bond markets, but it certainly does give me a little bit more security that at least whatever changes do occur, they will go through a vetting process. And it seems to me that we watched a vetting process take place, at least when it came to the 899 section. And I wonder how much other certainly from a tax policy, from a tariff policy, how much of this is actually a very dramatic, some might say overly dramatic, vetting process of ideas and structural reform that might take place over time. My hope is that the worst fears that we might have will not be realized, and that actually we will muddle our way to something that's more rational. But the key here is the surprise. How do we keep ourselves from being surprised by it? When we think about what happened in June and how we backed off 899, it did not happen because of U.S.-based asset managers having a conversation with the politicians, kind of explaining what the impact of this. It wasn't the international community for the most part. Would you agree that pushed them to understand what the implication was?
I agree, Gunnar. It was really about the impact of the overall U.S. economy and the impact on U.S. taxpayers. And this is where I really encourage foreign investors to be part of a community like AFIRE, where they can be connected with other LPs with similar concerns, but also importantly with the U.S. GPs.
Right.
As a community, they can stay informed on issues that's relevant to them, help them filter out the noise, and also help educate each other on the potential impact that a particular tax proposal could have on investment returns.
It does seem to me, especially in the current administration, that the greatest impact isn't coming from other nationalities. It's not coming from other countries that's going to steer where this government is going, that it's going to be domestic concerns. And therefore, to your point, that relationship between the U.S.-based asset managers and the institutional capital from around the world, it's important that we're communicating constantly, that we understand, that the U.S. folks understand what the issues are for someone sitting in Liechtenstein. I mean, we have to understand what those things are, and we have to have that communication. And obviously, I agree. Everyone should come to AFIRE. That's important. But I think even more important than that is that everyone is spending time talking with their colleagues across borders and doing it in a somewhat safe environment where it's not necessarily about what's on the record, but it's about, what are the issues and how do we sort the noise from the signal? How do we understand how we're not going to freak out and instead focus on what can be done and what should be done? And I think you're right. The persuaders are sitting inside the U.S. economy, the persuaders for how these things should be crafted on a go-forward basis as they change. The bond market, I wish the bond market were a person that I could take out, for dinner and persuade. It doesn't seem to be the case, but understanding what's happening in the bond market, what the concerns are, and to be able to see it, certainly from a real estate perspective, pretty important because it is a major, if not one of the biggest drivers of what happens in the economy is what happens in the built environment. That we as a community, and I really do mean we, it doesn't matter what country you're in, whether you're an LP or a GP, that we are having to work together and understand who are the best and what are the best persuaders to essentially keep that growth agenda going. Would you agree?
I absolutely agree. I think in terms of information sharing at the law firm, we definitely publish client alerts, which is a great way to keep up to date. There are various news sources that are also very good. Their trade organization, which also publish really good newsletter, but nothing beats a community of like-minded people coming together, sharing information and brainstorming.
What do you think a lot of investors maybe aren't paying enough attention to now? What information should we be spending more time thinking about? Or what is the misunderstanding that we might have around tax policy that we should probably rethink? So when I think about what are the sources for that, because obviously to read everything that comes out of Congress is a brain melting experience. And, how do you sort through it? How do you understand the actual impact on it? I've been over the years, and I certainly recommend this to anyone in the real estate business. I pay very close attention to the regular reports that come out of the Real Estate Roundtable, which is one of the lobbying organizations for real estate that has focused a lot on tax policy. And they have some really wonderful thought leaders working there. And they do a nice job of summarizing that on a weekly basis. So people should subscribe to that. But one of the things that I discovered during this process was the wonderful information that came out of DLA Piper.
We publish a quarterly REIT newsletter summarizing all the development from the last quarter. That includes both private letter rulings, change in law, and legislative proposals.
And I'd also encourage, certainly, you're not the only law firm that has a tax practice that has wonderful information. Depending on, who your outside counsel is, I'd certainly ask about that. But, my new favorite, especially after June, is certainly your newsletter. But I do think it's important to dip into that. And even if you're not counsel, even if you're not the tax specialist within the company, it's a good idea for a strategic leader to dip into this from time to time to learn what questions to ask and where to focus.
Yeah, thank you. So I think if we take a step back, we continue to believe that the current tax policy here is one of growth and one that encourages foreign capital. But what we do see in our daily practice in negotiating contracts and agreements for investors is that the change in law risk provision is now a more contested and more negotiated provision than it had been in the past. It is exactly what we've been talking about during this podcast. In the past, people didn't feel like there were much of a risk of the laws changing at all. So your regular change in law risk provision, people are just kind of, I'll sign it. It's not going to change. It's fine. But these days, people are pretty hyper-focused on, okay, if we are going to protect you for change in law risk, what exactly are we doing here? What are we going to define as a change in law? Because another thing that 899 showed us, which is a little unique, was that before, foreign investors might feel like absent a treaty, the change in law for all foreign investors are falling really along the same lines. It's not on a country-by-country basis when it comes to the domestic internal revenue code. But what 899 has shown us is even absent a treaty, sometimes domestic law could apply on a country-by-country basis. And therefore, each country's risk for changing law can be different from each other.
And should be tracked depending on, where you're coming from and where you're going. It should be something that's just generally tracked, check in on a regular basis. And a new process for us to go through, I think, after years of really just kind of, rubber stamping, what that issue might be or what that issue might not be, that we do need to pay closer attention to it and somehow do that without getting too freaked out. It's a fine line between freaking out too much and paying close attention, but I think an important one for us to pay attention to. Well, we've been talking with Shiukay Hung, who is from DLA Piper. He's the partner and co-chair of the National REIT Tax Practice. And we'll be speaking at our annual meeting in September of 2025. I encourage everyone to come to the meeting, and especially everyone from AFIRE to come to the meeting, and to make sure you pay attention to where we need to think about tax risk, tax policy risk, on a go-forward basis. So thank you, Shiukay, for joining me on the AFIRE podcast.
Thanks so much for having me.
You have been listening to the AFIRE podcast. Remember to subscribe on your favorite podcast subscription service, such as Apple, Spotify, Google, Stitchers, and others. AFIRE is not engaged in providing tax, accounting, or legal advice. No content in this podcast is to be construed as a recommendation to buy or sell any asset. Some information included has been obtained from third-party sources considered to be reliable, though AFIRE is not responsible for guaranteeing the accuracy of third-party information. The opinions expressed are those of its respective contributors and sources, and do not necessarily reflect those of AFIRE.